distinguished colleagues, ladies and gentlemen. I have my remarks prepared. Over the course of the last couple of days, a lot of interesting stuff has come up, and I've been making additions, but then having seen the ruthlessness of the timekeeping this morning, I'm now trying to work out what I need to take out from the additions I've made, so just bear with me as I go along. Yeah. First of all, I'd like to thank the Department of Justice and Corrections, Legal Aid South Africa, UNDP, UNODC, and the ILF for inviting UNICEF to speak today, and also for taking a whole session to recognise the importance of promoting children's access to legal representation. And with this panel today, the conference is contributing to a dialogue around the world which impacts the lives of millions of children and youth today. And I use that vague number, millions, because first of all, one of the issues that we face and one of the challenges is that we don't have very good data on the exact number of children who are coming into conflict with the law globally. That's data that's robust and that we can rely upon. We do have a figure of 1.1 million for the number of children who we believe are being held in detention, but that's quite an old figure. It needs updating, and we can say that the vast majority of those children probably would have received a lesser sentence if they had had access to adequate legal counsel, and that many of them are also being held in pre-trial detention, which probably could have been avoided if they'd had access to legal counsel. As I'm sure you're all aware, we're rapidly approaching in November the 25th anniversary of the Convention on the Rights of the Child. And the CRC does contain particular 3 articles which enumerate states' obligations towards children who are in conflict with the law and who find themselves in contact with the justice system. Article 37 is predominantly regarding the limitation of the use of the deprivation of liberty. Article 39 calls for appropriate measures for physical and psychological recovery and social reintegration of child victims. And Article 40 establishes all justice interventions should be promoting reintegration and the child's assuming a constructive role in society. And in Article 40, the CRC also lists the main legal guarantees which should be afforded to children in conflict with the law, most relevant to this conference, including the right of a child to legal or other appropriate assistance in the preparation and presentation of his or her defence. And Article 37 reinforces this by again stating the need for children to have adequate and appropriate legal assistance if they are deprived of their liberty. However, crucially, the CRC doesn't, in a plain text reading, obligate states to ensure that children accused of a crime or suspected of having committed a crime are entitled to prompt legal assistance from the moment of arrest or apprehension and or during questioning and initial interrogation. And this principle needed further enumeration and codification in other international instruments. And that's come most notably and most explicitly, firstly in the UN Principles and Guidelines on Access to Legal Aid in Criminal Justice Systems, but then also has been further developed in the UNDP, UNODC Handbook on Early Access to Legal Aid, which contains very specific recommendations and provisions for states regarding early access to legal aid for children. And establishing this principle of early access from the moment of apprehension and arrest as a basic standard in national legislation and policy is of the utmost importance, because it's during this initial phase of a criminal investigation that the most opportunities in most jurisdictions exist for a child to be diverted from the formal criminal justice procedure. And one of the speakers this morning, Donna, noted that to a certain extent the system has already failed if we arrest a child, because we should be trying to divert children away from the system. But there's also a wide window of opportunity between arrest and indictment, where prosecution and police retain the discretion in many jurisdictions to either give the child a caution, some form of warning, or to divert them into a non-punitive form of resolving the matter before them, and that doesn't result in a criminal record. Although that decision rests in most cases with the prosecution and the police, the presence of a legal advocate who is driving and pushing those prosecution and police to take that option, reminding them of their responsibility to act in the best interests of the child at that stage is vitally important. And the role of legal assistance in promoting the rights of children is crucial then throughout the investigation, trial and detention period, precisely because the CRC and subsequent international instruments give children very specific rights within the criminal justice system over and above their right to due process and a fair trial. And so legal assistance for children in conflict with the law doesn't merely entail ensuring the best possible legal advice and representation for the child in terms of their case regarding the criminal offence for which they are alleged to have committed in the usual sense of due process and a fair trial. But it also means acting as an advocate for the child to ensure that all special procedural safeguards and measures designed to protect children in the criminal justice system are respected and adhered to. Now, that's a role that carries a lot of responsibility and importance, and in order to ensure that it's undertaken properly, it's vital to ensure that those lawyers who are assisting children, or paralegals, or law students, or lay workers with some training, have specific training not just in the criminal law pertaining to children, but also in child rights in general, and as we discussed in one of the breakout sessions the other day, in a basic understanding of developmental stages of children, in child psychology, and in how you communicate and work with a child. Because interrogating and interviewing a child of 9, of 14, of 17, these are very different things according to different stages of development. And understanding how you do that is crucial to be able to build the best possible case and defence for your client. Now, that specialisation requires training, and of course training requires money, and that's something that we've repeatedly heard over the past few days is something that is in very short supply for legal aid systems. But the investment is a pretty sound one. Aside from the moral and normative imperative of moving states towards meeting their obligations under the CRC, we do have to consider that a child's experience of engagement with the justice system is likely to shape also and influence their perception and their relationship to the state as a whole. And if a child perceives that justice is simply something that happens to them without any chance for their voice to be heard or for them to express their opinion or have their story told, and that they're facing the entire apparatus of the courts, law enforcement, judiciary, with no one there to defend them, then they're not likely to grow up with much faith or investment in the institutions and representatives of the state. And the same applies if their legal counsel is a generalist who turns up 5 minutes before the trial and proceeds without consultation with them into a plea bargain. As David McCoy-Mason pointed out in his presentation a couple of days ago, this at worst can lead to a level of disaffection with the state and its representatives that can drive conflict. But it's more usual, I think, simply that it results in a more generalized level of disengagement with society and with public and community life. And that is one of the factors that can mean that a child's first engagement with the legal system is not their only engagement with the legal system. And so whilst the provision of legal counsel doesn't entirely mitigate the risk or guarantee that a child won't reoffend, it's certainly an important contributory factor. And the cost involved in ensuring that aid is small in comparison to the possible future consequences. And one of the other things we've heard a lot of in the last few days is the need to try to document and quantify that cost and compare the cost of providing legal aid to not providing legal aid and subsequent imprisonment, and then what the child does in later life. Now, UNICEF at the minute is investing in quite a lot of work in this area, but I'm being told to wrap up. One sort of qualification to this I will add is that we're using something called the cost of inaction methodology. And this tries to document what is the cost of not providing this one particular service, not taking this one particular action. It's an extremely expensive methodology. It's extremely complicated. And I think there's also a danger of us relying on these kind of cost analysis and cost arguments as a silver bullet that are going to solve the policy dialogue problems and challenges we face. And when one is talking about very complicated hypothetical economic models to be presented to politicians, it's worth remembering that they're going to have a limited usage perhaps in that dialogue. There are a couple of other things I wanted to say, but hopefully I'll get a chance to do so in